Okay, we're going to jump into the elements now. First, we're going to look at what the plaintiff needs to prove, and then we'll look at what the defendant needs to prove to be accepted from avoidance. This is 547B, sets out the laundry list applicable to the plaintiff. Okay, the first thing we're going to look at is what does this mean? Except as provided and subject to the C and I of this section, the trustee may avoid any transfer of an interest of the debtor in property. Well, what does that mean? Well, before we can figure out what a transfer of interest of the debtor in property means, we need to know what a transfer is. Actually, we're lucky here. It's actually defined in the Bankruptcy Code. What's important to take away here is that it doesn't have to be a check or cash. It can be the creation of a lien, the retention of title as a security interest. So a lot of different things can be transfers, can be involuntary, could be voluntary. So what you think may not look like a transfer can very well be a transfer. We're going to take a look at some indirect transfers and show why they are considered to be preferences. At first, indirect transfers are a little bit counterintuitive. So the debtor pays somebody else. Why am I being sued? I wasn't paid. Well, the preference laws look underneath the forms of things and look at what actually happened. So in a case like this, debtor A owes money to creditor B, and you happen to be creditor B, and you owe money to creditor C or entity C, and the debtor pays directly entity C, you could see why you're getting a benefit. Why is it important that you're getting a benefit? Because that's part of the first element, to or for the benefit of a creditor. I could have put this case under either transfer or benefit, but I think it's important to know that this could be a transfer. It doesn't have to be a transfer to you. It could be a transfer to another party. Well, this is a pretty good example of an indirect transfer. In this case, Clemens sues the debtor, Thermoview Industries, pre-petition prior to the bankruptcy case, gets a judgment, and Thermoview puts up a bond with an insurance company to stay enforcement. Thermoview files for bankruptcy, trustee sues Clemens and the insurance company to get back the funds as a transfer. Clemens argues that the $300K that the debtor put up was not part of the bankruptcy estate, and the judge says, "Hey, the estate was diminished by $300,000. It was part of the bankruptcy estate, and the transfer to the third party, an indirect transfer, was to the benefit of Clemens, and was voidable as a transfer." This is an interesting situation that happens a lot. A troubled company is sold. The buyer assumes liabilities. So the buyer accepts responsibility to pay the debtor's creditors prior to the bankruptcy case, and does pay the debtor's creditors. So what happens in a case like this? An example of this is Henry Food Catering out of the Ninth Circuit, 1992. Okay, so typical situation, third party buys all the debtor's assets, assume all liabilities of the debtor, and then does pay a creditor, and the debtor files for bankruptcy. So in this case, third party paid $24K to a creditor. So why is that a preference? Why? Because instead of the debtor paying the $24K, the debtor reduced the sale price of its assets by $24K or more, depending on how many creditors it owed. And it's basically an indirect. So it got $24K less prior to the bankruptcy, and there are $24K There's 24K less of assets to distribute. It's clearly an indirect preference. The creditor could have gotten paid by the debtor, got paid by the third party, but the debtor got less money for its assets. So the effect is the same on unsecured creditors. Another way the court framed this is that the purchase of assets and assumption of liabilities was to or for the benefit of a creditor. It was to or for the benefit of the defendant. The defendant benefited from the assumption of debt and the payment of less for the assets. This is a very similar case to the last one. It involved the purchase of assets and assumption of liabilities. In this case, the consulting company was paid by a third party. Same rationale. The judge basically looked at this and said, look, this was part of the consideration of the purchase of the assets. It was to or for the benefit of the creditor. It was just an indirect payment. Otherwise, they would have paid more for the assets, including consulting agreement, which was essentially a debt that they assumed, that the third party assumed, and the estate would have had more money. So it's the same difference. It's just a graphic slide of the case. I mean, it basically shows the same thing. What's important to take away here is that the effect on the estate is the same. Whether the estate accepted less money in the amount of the liability or whether the estate paid the creditor directly, it's the same impact on unsecured creditors. There's less money to transfer, and this guy gets paid in full. So that's why it's a preference. The court said there was a direct and traceable link. Okay, well, basically in a situation of an indirect transfer, the court's looking at what happened here and what's the effect. Preferences can be involuntary. What's the takeaway here is that a lot of people see preferences. Oh, this is a sweetheart deal between the debtor and the creditor. The preference is being preferred by the debtor, but it doesn't have to be a sweetheart deal. In fact, there could be no love lost at all between the parties. An example of an involuntary transfer is a creditor sues the debtor and liens its bank account, and the lien is placed or the monies are transferred during the preference period. It's involuntary. Debtor is not choosing to pay the creditor. It's forced to. This is just an example of an involuntary transfer. Maytag was sued by the county. Sheriff levied the bank account, and the money was taken out during the preference period. If anybody wants to look at this case, not going to go into a lot of detail on this one. That's just an example of an involuntary, how a preference can be involuntary. Okay, well, a lien can also be an involuntary transfer. Actually, just placing a lien. That's what the point is here. It doesn't have to be a lien that's liquidated and turned into money. In this situation, Hawkins provided professional services to the debtor before the bankruptcy. Obviously was not paid and was not too happy about that, and sued the debtor and got a lien during the preference period. Issued a writ of attachment on certain logging equipment and real property belonging to the debtor, but didn't actually get any money, just put the lien on. Well, trustee sought to avoid the lien. Defendant argued that the debtor was solvent. Even if the debtor was insolvent, it's just a lien, and somehow 547b5 would not apply. I don't really see how, but at any rate, that was the argument. Court found that the trustee showed that the debtor was insolvent and that without the lien, he would just have an unsecured claim. And so during the preference period, he was elevated from an unsecured claim into a secured claim. And so would get payment in full. Thus, the end of the story is that the lien would have enabled the defendant to receive more than he would have without the lien in a hypothetical Chapter 7 case. It was a preferential transfer. All right, so we have some concept of what a transfer is. So we're back to transfer of an interest of the debtor in property. Let's take a look at property. Sometimes there's a question of whether it is the debtor's property or was the debtor's property. What if a third party pays the debtor and says to the debtor, I want you to use this money to pay creditor A, and the debtor pays creditor A. So did that really become the debtor's property? That's the theory behind a line of cases falling under what's called the earmarking doctrine. In this case, the parent company of MCM, the debtor, transferred funds to the debtor so that the debtor could pay part of the settlement that was agreed to with Berkeley Underwriting. So the issue is, did the debtor have control over these funds? Was there an instruction, a specific instruction by the parent company to keep these funds segregated, to only pay Berkeley with these funds? Trustee argued that there was not a specific agreement to do that or a specific direction, and there's an issue of control. In this case, the judge found that there was an issue of fact, and the judge ordered a trial. So the opinion simply denies motions for summary judgment by both sides. I just wanted to use this case to illustrate an example of this doctrine. Generally speaking, after reading a lot of cases on the earmarking doctrine, I have to say it's a very hard defense to prove. What you have to prove is there was a specific instruction, and it's an issue of control. Did the debtor have control? Did the money go into the debtor's general account? Was the money segregated? Did the debtor have a legal obligation to pay the creditor? In other words, was the debtor merely a conduit for the funds, or was the money paid to the debtor, and the debtor could have done whatever it wanted to with this money and chose to pay that creditor? So that's the issue, and most of the time, in my experience and from reading the cases, this defense doesn't work. This case is another example of the earmarking defense, and not surprisingly, is another situation where the earmarking defense goes down in flames. The entity that made the payment was the end user. Bender Shipbuilding was a shipbuilder working for ATI. ATI made a payment in the preference period to both Bender and arguably to Malone Consulting, but it didn't pay Malone directly. Malone was a subcontractor. It paid Bender with the intention that Bender would pay Malone, and the instruction that Bender pay Malone. Obviously, ATI may have been concerned about the financial stability of Bender, with good reason, and concerned about potential liability to the subcontractor. Well, the judge found that ATI, well, it made a request. It did not demand or require that a separate segregated account be maintained and that the funds go into that account on behalf of Malone. And that Bender did not automatically make the payment immediately. Just uh, uh, intermingled it with other funds and eventually paid them a loan. Bender had clear control, and there was just an insufficient um, specification of a demand by ATI that these funds could not be used for anything else. That's the only way the earmark defense really works. And also, probably for it to work, the funds need to be paid into a special segregated account. This case is an example of an earmarking doctrine, but a sort of an example of just a property issue. Was it property of the estate? In this case, the debtor used money in the debtor's mother's bank account to pay the debt of a third party. And so the question is, did the earmarking doctrine apply since the funds did not come from the debtor, but theoretically came from the debtor's mother? And so the defense was the earmarking doctrine applies, and the debtor was just a conduit. Actually, the mother paid the creditor. The bankruptcy court actually looked at whose bank account it actually was and found as follows. The bankruptcy court found that there was an issue actually as to whether, first of all, the debtor had control over his mother's bank account. His mother didn't do anything. The debtor had complete control and cut a check using his mother's account. And then evidence was developed during the case that showed that the debtor had an inheritance and his mother was holding the money. And so there was an issue whether this was the debtor's money anyway. And at any rate, this was a loser for this defendant. He should have just cut a deal and stayed home. Another defense doctrine is diminution of debtor's property. In other words, if the transfer does not result in a lessening of the debtor's estate, then nobody's hurt. So what's an example of that? Well, in this case, what the debtor did was borrow money from another creditor and paid off this credit card to MBNA. So MBNA argued, well, you're just switching creditors here. So she has a new creditor. We're the old creditor. We got paid off, but she's got a new creditor. So there's no loss to the estate here. The funds came from a new creditor. Well, I just said that. The bankruptcy court didn't buy it and found that it was an issue of control. That the debtor could have decided not to pay this particular creditor, and that it was the debtor's choice, and because of that, this doctrine should not apply. This doctrine is along the same lines. It says that if the funds were held in constructive trust, it's not property of the debtor. Well, this is one of the most ridiculous cases I ever read. I just can't believe the aggression of this trustee. So this was basically a check that was meant for the defendant, that was sent to the debtor by mistake. The debtor deposits it, I assume by mistake. And then during the preference period, the debtor transfers the funds back to the defendant. And these two parties had nothing to do with each other, just happened to be in the same building. Unbelievably, the trustee sues this very unfortunate defendant for a preference. It's bad enough that it doesn't receive its checks in the mail. Now it has to be sued for a preference and hire a lawyer. I just find this just unbelievable. Well, surprise, surprise, the trustee lost. The defendant was not a creditor, and the money was held in constructive trust. It never became the debtor's a property. I really hope that that this trustee was sanctioned and that these guys had the trustee pay their legal fees. Okay, so let's move on to the first element, the first enumerated element, to or for the benefit of a creditor. I touched on this before, but we'll go into more detail. All right, what's a creditor? Well, this is an interesting defense theory as well. The conduit defense theory. This is another one of those what could he possibly have been thinking cases, and I'm saying this about the trustee again. This is debtor settles a case, pre-petition, before the bankruptcy. The funds are wired to the debtor's counsel. Counsel keeps the funds in escrow, takes out his or the law firm's fee, and holds the funds in escrow. And of course, these funds were received during the preference period. To me, there's plenty of case law. This was in 2011. There's plenty of case law before this that shows that the lawyer is not a creditor, simply a conduit, and that's the conduit theory. Lawyers acting as a conduit. Money goes in, money goes out. Somehow the trustee decided to sue anyway, and the result was pretty predictable. The court found that the lawyers were not creditors. The debtor did not owe any debt to the lawyers. The lawyers were simply a conduit. They were an agent of the debtor, but they were simply a conduit of the funds. Okay, well, what does that mean? Benefit of a creditor. We had an example of this earlier, but we'll take a look at another example. Let's say you guarantee a debt that the debtor has to creditor A. And during the preference period, the debtor pays creditor A. Do you get a benefit from that? Unfortunately, under the preference law, you do. Well, let's take a look at this case. Also a pretty recent case from Wisconsin. All right, in this case, mom tries to get a loan from the bank, denied, goes to her good son. The good son says, I'll guarantee the debt. Bank makes the loan. Mom repays the $45K during the preference period, goes bankrupt, and trustee sues the bank and the defendant's son. Defendant's son says, who, me? I'm not a creditor. Why are you suing me for? Well, unfortunately for the son, did everything right, but he did benefit from this. Why? Because he had a contingent right to payment from his mom, so he was a creditor, and obviously the payment extinguished his guarantee, so he benefited from that as well, since he no longer had a liability with the bank. The court held that the payment was avoidable from the son. Next time your mom asks for a loan or a guarantee of her loan, you really got to think twice about it. Okay, on to element number 2. For or on account of an antecedent debt owed by the debtor before such transfer was made. Well, that's a mouthful. Let's just focus on antecedent debt. What's that, or what isn't it? Well, BRW paper came up with sort of an interesting argument to a preference lawsuit. Debtor was a printing company, and BRW supplied paper, and during the preference period, they received a payment of $18,900, a timely payment of their invoice, and they argued, well, it's not past due, it's not antecedent, not an antecedent debt. It's a colorful argument, I suppose. but you can guess that it didn't work, and you'd be guessing right. The argument didn't work. Doesn't matter that they paid within terms or according to terms. It was paid pursuant to an open line of credit, and any payment paid on as part of a credit transaction is payment of an antecedent debt. In this recent case, a wholesaler of magazines and books was sued by the debtor, and the fact pattern is a little bit unusual. In this case, the vendor was paid during the preference period pretty much on the same day as the invoice. So the invoice date was the same as the check date, except for one check, and that was, and the date of that check was immediately after the date on the invoice. So the defendant argued it's not an antecedent debt. It was an immediate payment. What happened? Defendant wins for a change. Yes, the court decided in favor of the defendant because there was an immediate payment of the invoice. Court found that it was not essentially a credit transaction, and there was no antecedent debt. Okay, the third element, made while the debtor was insolvent. Well, what does that mean? How do you define insolvency? Well, 101, as you could tell, defines insolvency. The question is, what's a fair valuation, and how do you do a valuation of a debtor's assets and liabilities? It's a very, very fact-intensive inquiry, and as you can imagine, it's a very expensive one. So it's typically only very large cases. In only very large cases is valuation and insolvency litigated. Why? Because you have to hire experts. Both the plaintiff and the defendant will need to hire experts. And since it's fundamentally a fact issue, it's going to have to be decided by the judge at trial. It's a very expensive process. Valuation of a debtor's assets and liabilities is very complicated. There are a lot of ways of going about it. It's really beyond the scope of this basic CLE video. Suffice it to say, the assets can be valued from the perspective of going concern valuation. In other words, if the business is a going concern, the business is continuing, then the assets are going to have a certain value. And if the business is dead and just being parted out, the assets are going to have another value. But this is a complicated area. I'm just going to go into one case just to give you a taste of it. The issue in this case was the valuation of a chemical company that was the debtor. And one of the main issues was whether the chemical company should have been considered, sort of been valued as a going concern, or should be valued as liquidation value. In other words, a forced immediate sale. The judge decided that even though the company had not shown a profit in a few years, it was not in such bad shape that it should be liquidation value. And so the court decided to value as a going concern. The other argument by the defendant is that the assets, as indicated in the schedules that showed solvency, should be given a lot of weight. And unfortunately, the judge disagreed with that argument and ultimately found that the company was insolvent, even when using a going concern valuation methodology. Element number 4 sets out the preference period, 90 days, on or within 90 days, in case you're asking. If you get a preference on the 90th day, it's still within the preference period, or a year in the case of insiders. But the question is, what does made mean? So what does made mean? Actually, this makes me think of the Clinton presidency, but actually, there was a lot of litigation as to what made means. It has to do with the timing of the transfer. The Supreme Court case of Barnhill versus Johnson decided the well litigated issue of whether a transfer is made when you receive a check as a defendant, when you receive a check in the mail, or when the check clears. Barnhill decided once and for all, for the purposes of timing of a transfer, whether a transfer is in a 90-day period or not, that the relevant date is the clear date. Rationale for the decision, as described by the Supreme Court, is basically a check is a piece of paper and could easily bounce and be returned with insufficient funds, and that really to comply or to comport with the definition of 547E2A, the transfer takes place at a time. At the time it takes effect between the transfer and the transferee, you have to be talking about a transfer of actual money. So it's the clear date when the money is actually transferred. I'm not going to go into a lot of detail on liens and when they can be preferences and the exceptions there too. What I want you to take away is basically that the perfection of a lien may be a preference if it's perfected during the preference period. We'll take a look at a case called French v. State out of Ohio, a fairly recent case. This kind of litigation, it's really a matter of state law. When a lien gives rise to a security interest, when the lien is perfected. Here, a judgment was obtained by a creditor. He argued that he had a lien prior to the preference period, and the trustee argued that he didn't have a security interest until it was perfected during the preference period, and the court agreed and basically held that the perfection of the lien was a transfer that occurred during the preference period, and it was successfully avoided. But each case, you have to look at the state law. The bankruptcy court will apply the applicable state property laws. It's just a chart basically showing what happened here. The moral of this story is perfect your lien right away. If there's a bankruptcy and you don't perfect, or you try to perfect during the preference period, you've wasted a lot of time and money. Well, that would seem pretty clear. 90 days before the date of the filing of the petition. Well, what about if it was an involuntary case? I mean, this issue is important because in an involuntary case, a petition is filed, but the court can then decide later not to enter an order of relief. In other words, the court can bounce the case, and there's a so-called gap period between the time a petition is filed and that decision is made. So when does the deadline start to run? The answer is on the petition date. So that's really all you need to know. So it's not when the order of relief is entered by the judge, it's the date the petition was filed. And that sets that controls the 90-day period. Insider is defined at section 101.31 of the Bankruptcy Code, and it gives you a laundry list of who is a statutory insider. I'm not going to go into this in a lot of detail because I think it's beyond the scope of the course, but that you're aware that a transfer to an insider is going to create a longer window of vulnerability before the petition date. Affiliates are deemed insiders. I'm going to just take a quick look at this case. I thought it was interesting because in this case, this was a president of a company that was forced to resign, and the issue was whether his golden parachute, so to speak, was a preference or not, and the issue is whether he was an insider. Of course, he argued that he was not an insider and that it was the transfer was outside the 90-day period. And he argued that he was not an insider because he was not on the list of categories of statutory insiders. The judge was swayed by the trustee's argument that the issue is not whether he's on the list, but whether he's an insider based on the lack of arm's length negotiation that took place with respect to the payment to him that was made within a year prior to the filing. The court noted that the case law does support that an individual may be deemed, or an entity may be deemed an insider if there's if there's evidence that there's lack of arm's length bargaining. Here, the court did find such evidence. I looked at a number of different factors. There was friends, that there were other issues also that would indicate that this was not an arm's length transaction. The takeaway here is that just because you're not a statutory insider doesn't mean the court can't find you to be an insider. Here, the court didn't render a decision in the opinion that I cited, but merely denied motions for summary judgment by both sides and decided that whether the defendant was an insider was a fact issue that had to be decided at trial. Whether someone's an insider is a pretty important issue if the transfer was outside the 90-day period, because if you're not an insider, case is over. One of the issues that comes up is whether the defendant was a relative of an officer, or if the debtor's individual is a relative of the debtor. This is the laundry list in 101.31 that defines a statutory insider. And you can see relative is one of the, being a relative is one of the, can be one of the statutory definitions of an insider. But even the term relative is defined, and it's limited, as you can see. So unbelievably, there is litigation on this issue. And here we go, Gold versus Rubin, a fairly recent case in Michigan. Well, the question was whether Yitzhak was an insider or not. He received $22K, and Yitzhak argued that as a second cousin, he should not be an insider. Trustee argued, of course, that the second cousin was within the third degree and he should be an insider. So the question was, what is a second cousin? And the court looked to state law to decide. Drum roll. He gets off the hook. Court found that a second cousin is not a relative under the Bankruptcy Code. Although, personally, I'm not sure I want my second cousin marrying my daughter, but I guess we all have different. It's all relative. That was my introduction. It's all relative. Okay, we get to the hypothetical Chapter 7 distribution test. This is 547b5. This is my favorite section because I think it has kind of a Twilight Zone feeling to it. So hypothetically, if there was a Chapter 7 case and you were still hypothetically a creditor and there was a hypothetical transfer at that time, what would you have done? It's kind of like an alternate reality kind of code section. Okay, let's take a look at Luker versus Heartland out of Arkansas. Relatively recent case as well. So there are two questions. If you hadn't repaid the transfer during the preference period, and there was a hypothetical Chapter 7 case, and you hypothetically filed a proof of claim, and you were hypothetically paid through the Chapter 7 case, would you have been paid more by getting the transfer, or would you have been paid the same amount or less if there was a Chapter 7 case? The analysis here can be complicated, but the takeaway is that if you're an unsecured creditor, you're getting 100 cents on the dollar by a transfer pre-petition. If unsecureds are getting paid anything less than 100 cents on the dollar, which is typically the case, then you're getting paid more by your transfer than you would get paid in a hypothetical Chapter 7 case. What gets more complicated is if you're a secured creditor pre-petition and you get paid 100 cents on the dollar, then you're paid out of your collateral post-petition, and the argument is you're not paid more pre-petition because you're secured and you're paid out of your collateral if there's a hypothetical Chapter 7 case. The case we're going to look at is a situation where a secured creditor is partially secured. And so the litigation is going to focus on, well, are you a secure creditor? To what extent are you a secure creditor? And this is at the time of the transfer. So that's where the litigation kind of focuses in the 547 B5 analysis in most cases. In this case, the debtors were two doctors at medical clinics, and they were way in over their head to a number of creditors, and one of the creditors was a bank. And when they sold the business, to simplify things, $500K went to the bank pre-petition. And so they went bankrupt, and Trustee sued the bank. And one of the issues, there were other issues, but one of the issues was the 547 B5 analysis, and whether the bank would have been paid less in a hypothetical Chapter 7 case. The bank argued that things happened, which we won't go into now. You can read the opinion post-petition, that would render them having been paid full if there were a hypothetical Chapter 7 case, and the judge rejected that argument. The judge basically concluded that at the time of the transfer, if there were a hypothetical Chapter 7 case filed, and the bank was only partially secured, which it was, then the bank was getting paid more pre-petition by the pre-petition transfer than it would have been paid in the hypothetical 7 case. The other issue was the amount that the bank was secured, and there was an issue with the bank not supplying enough evidence to show exactly the degree to which it was secured, and the judge found for the trustee. Well, I emphasized the transfer had not been made because, well, what would have happened hypothetically had the transfer not been made? That can create some issues. And again, it gives me sort of a Twilight Zone feeling, but here we go. Lex versus Fifth Third Bank. And Fifth Third came up with a successful argument here. Well, this is an interesting case. The bank argues that, okay, it was paid $500K and change during the preference period, but it was owed more money. And it had a right of set-off under 553A, which applies state law. So under the applicable law, which was Ohio law, they would have the right to set off. The important thing to understand about this case is two things. First of all, you're going to have to learn a little bit about set-off. And the point is that bankruptcy recognizes state law set-off rights. So in other words, If there were no recognition of set-off rights, the trustee would say, okay, you got paid 500K in change, and then you're owed 500K, but just put in a bankruptcy claim and you'll be paid an unsecured claim. Pennies on the dollar. But the fact is that the bankruptcy code under 553A recognizes set-off, so that the bank is saying, well, if there were a Chapter 7 case, if we hadn't been paid and there were a hypothetical Chapter 7 case, then we would do what makes sense. We would set off the claim against what we're owed. And so the bank is making an argument that you have to respect what the bank would do hypothetically if it acted rationally, which I think is interesting. So you have a whole hypothetical situation here that's assuming the bank would act rationally and protect its interests. The court agreed with the bank and found that if there were a hypothetical 7 case, so the presumption is that the bank would act rationally and hypothetically pursue its set-off rights under 553A. I mean, you kind of have to ask, I mean, how far do courts take this hypothetical scenario? And the answer is they take it pretty far. And there are other cases where the assumption is that a creditor is going to act rationally and maybe not have set-off rights, but let's say have a hypothetical lien right. I'm not going to go into those cases, but anyway, the hypothetical ability of a creditor to hypothetically act in a rational way is definitely respected under this section.